Hello everyone, I hope you're all doing well. My name is Menna Hijzai and I'm glad to have this chance today to discuss the public order exception in a private international law topic. So as you can see, here are the outlines for our topic for today. We're gonna start with an introduction. So meeting the requirement of public order and morality is one of the prerequisites for the execution of a foreign judgment. شو يعني هذا الكلام؟ يعني before examining, applying the foreign judgment, we should look at the internal or national public order, if it's going in line with it or not. If so, then the foreign law would be applied, and if not, it would be rejected by the judge. We must understand that the choice of law rules being the law of lex fori only, and there being no restraint imposed by private international law. وهيك يعني the foreign state is free to refrain from following the outcomes indicated by its usual choice of law. ورح نشرح هذا الكلام لقدام بشكل مفصل أكثر. إذا حابين تتوسعوا أكثر بهذه المعلومات، تطبيق القانون الأجنبي وشروطه، ممكن تطلعوا على المادة 36 الفقرة ألف من قانون التنفيذ الفلسطيني والمادة 37 من نفس القانون. Okay, moving to the definition. So there were several attempts to define the term public order by itself, بس بالآخر it's seen as a developed concept which finds its expression in various states, morals, ideological, social, economic, and cultural ideas, as well as its constitutions, statutes, and practice of courts. هذا هو ال public order بس. لكن public order under private international law يعني هو عبارة عن مجموعة من المبادئ الأساسية اللي بيرتكز إليها قاضي النزاع بهدف حماية الأمن والصحة والآداب العامة داخل مجتمعه. وهون مبين الإشي إنه it serves as a safety valve for a country to enable its court to deny effect to foreign laws and judgment, which for one reason or another should not be enforced. بدي أنوه إنه بعض السيستمز أو الدول بتستخدم مصطلح public policy للإشارة إلى public order under private international law، وهذا بيلعب دور أكثر يعني حزامة أو أكثر يعني it's more restrictive against the execution of foreign judgment. ليش؟ لأنه بيعتبروا إنه public order هو جزء من public policy as a whole. Anyways, these are examples of public order under private international law. ناخذ مثال البولوغامي اللي هو تعدد الزوجات. بنشوف إنه it is considered part of public order in Arab or Muslim countries, but it is prohibited in European countries. Likewise, divorce, adoption, gambling. Keep in mind, guys, that internal public policy differs in its history, scope, and social function from public policy in a private international law domain. So here I found an interesting expression that some jurists describe the public policy with. بيحكي إنه هو unruly horse, where once you stride on it, you do not know where it is going to take you. هذا بيحكوا لأنه بيشوفوا إنه it justifies the unpredictability of the interpretation of the term public policy. وبصراحة هو this term has led to the categorization of laws of law which public policy may be invoked. Moving to the characteristics of public order in private international law. As we can see here, it's dynamic and relative, it's national, it's diverse, and judicial. So first one, dynamic. How it is dynamic? It's dynamic regarding time and place, and relative because there is no constant standards that define public order. National because in the sense that each country has its own concept of public order, and وهيك يعني ما مش معقول إنه الكل يكون عنده one common or unified system to all to public order في كل systems. It's diverse because the public order affects all branches of law. It affects the public law, all its branches, بس branches معينة من ال private law اللي هو مثل ال working hours, succession, and age of consent. It's judicial, يعني the matter of determining what falls under the public order in a dispute that includes a foreign element is within the capacity of the judge who's hearing the dispute. رح نفصل هذا الموضوع لقدام أكتر. Speaking about public order exception conditions, it has to be a foreign law, and this foreign law contradicts and violates the foreign state's public order. يعني يجب أن يكون القانون المستند إليه قانون أجنبي وأن يتعارض أو يخالف هذا القانون مقتضيات النظام العام في دولة القاضي. هاي شروط مبدئية للدفع بالقانون العام. Who determines the dependence of the relationship to public order? Well, it's the judge who hears the dispute, is the one authorized to determine the dependence. But keep in mind that the decision he made or she made remains subject or under the surveillance of the Court of Cassation. بأصل عام أو القاعدة العامة هو إنه المشرع الوطني هو من يضع قواعد قانونية لتبين شو هو المتعلق بالنظام العام. لكن نظراً لأنه النظام العام مثل ما حكينا يتميز إنه مستجد وديناميك وإلى آخره، فالرأي الفقهي الغالب ترك مسألة تحديد ما يندرج تحت النظام العام في المنازعة ذات العنصر الأجنبي للقاضي الذي ينظر النزاع. Moving forward, we're going to talk about the basis or grounds to deny the execution of a foreign judgment for public order reasons. As we can see here, the foreign judgment obtained by fraudulent means. This is either as a consequence of an act of the party in whose favor the judgment was given, or of the foreign court is denied execution. يعني سواء هذا الفraudulent means كان بسبب تفضيل شخص من العلاقة القانونية على مصلحة الآخر أو لصالح المحكمة نفسها التي أصدرت القرار. The doctrine of public order may be invoked also when a foreign judgment is proved to be conducted by false evidence. How is that? It's through the expression of material facts, either cited or discovered, or when the foreign judge lack independence. شو يعني lack independence? Meaning they were themselves have interest in the outcomes of the action. يعني للقاضي مصلحة بالموضوع اللي أصدره. تاني نقطة اللي هي the foreign judgment rendered by a court of a state whose government is outlawed. شو يعني؟ يعني the judge from a state whose government is considered outlawed by the international community for violating fundamental rights and freedoms. المحكمة التي أصدرت القرار مخالفة للقواعد والقوانين التي تحمي حقوق الإنسان وحرياته الأساسية. The foreign judgment contradicts the foreign state's judgment over the same cause of actions, and this is either before or later to the foreign judgment. The foreign judgment is of a public nature. Of a public nature, we know that under the general principle of international law, the doctrine of the execution of a foreign law or judgment applies only to civil and commercial matters. وهيك the tax, administrative, and criminal judgments are denied execution. As we know now, applying public order principle is an essential requirement in the execution of a foreign judgment. But how or what are its functions? First point, it prevents the application of a foreign law which is repugnant in its nature to the recognition forum. Here, when the foreign law shocks the conscience and diverges from civilized standards, then it will not be applied. Indeed, penal rules related to this reaction against the foreign law. The second point is practical, and it prevents injustice in the circumstances of the particular case before the court. So it actually provides protection not from an especially repugnant foreign law only, but rather from its harsh application. We know that individual justice is usually de-emphasized in private international law, but here the employment of public order principle acts as a reserve equity principle. And this leads to the question, what are the demands of justice in the particular situation? As we see, it operates to exclude foreign law. But here, the third function considers public policy as a response to the considerable overgeneralization of public international rules. And in its effective invocation, it operated as a choice of law. Why do you think is that? As we mentioned earlier, because it is the application of Lex 40 that is preferred by the forum. The forum state is free to change its own conflict rules by the modality of public order. This is an opinion of one of the jurists in regard the previous matter, the third point. So when the public policy or order is playing this choice of law rule and not primarily performing the rule of a preventer of the application of a repugnant laws or avoider of justice, the controlling factor to its application will be the choice of law consideration. هاي آراء فقهاء مأخوذة من في كتير من الأنظمة في العالم ورح تلاقوها في المصادر وبإمكانكم تتوسعوا فيها لو حابين. Moving to the effects of denying the execution of the foreign judgment as a result of applying public order principle in private international law, there are two main effects. First one is a positive one. and it considers the application of the judge order. Second is the negative effect, and it considers the exclusion of the foreign judgment. Here in the second point, we have a question. Do we exclude the whole foreign judgment or only the part that contradicts the public order rules of the foreign state? كان هناك رأيين بخصوص السؤال هذا في الفقه القانوني. الرأي الأول مع الاستبعاد الكلي للقانون الأجنبي، وهذا كان على أساس أن تجزئة القانون الأجنبي سيؤدي من جهة إلى تطبيقه بشكل مخالف لإرادة المشرع الأجنبي، ومن جهة أخرى سيخالف رغبة المشرع الوطني بتطبيق القانون الأجنبي المحدد في قاعدة الإسناد بشكل كامل. الرأي الآخر وهو الرأي الراجح يتجه للاستبعاد الجزئي، وهو مع استبعاد الجزء الأجنبي الذي يخالف أو يعارض النظام العام في بلد القاضي، وتطبيق الجزء الآخر طالما لا يتعارض مع النظام العام في دولته. Mitigating the effects of public order in cases involving foreign elements. In case where the parties of the dispute rights arise outside the judge's state and are intended to be upheld in the judge's state. As an example of this, a Palestinian man married for a second time a German woman in Palestine. A dispute arose among them in Germany, and the wife filed a spousal support lawsuit against the husband before a German judge. هاي هي مثال على حالة تخفيف أثر النظام العام على تطبيق القانون الأجنبي. بنعرف إنه الأصل إنه الزواج الثاني غير معترف به في القانون الألماني، وهذا من النظام العام لديهم على خلاف ذلك في فلسطين. لكن هنا على اعتبار إنه النفقة هي أثر من آثار الزواج، وهو حق ناتج عن العلاقة التي تمت خارج الأراضي الألمانية بطبيعة الحال، فهنا الرأي الفقهي الراجح مع أنه لا يوجد ما يمنع من قيام القاضي الألماني بالحكم للزوجة بالنفقة على اعتبار أنه ذلك لا يخدش النظام العام في ألمانيا. The mitigation is part of the practical application of the principle of comity among states. وكثير من الدول بتاخده والأنظمة and this to enhance and support international economic relationship and so on among them. باعتبار إنه كل ما ضاق استبعاد القانون الأجنبي ازدهرت العلاقات الدولية الخاصة. لهيك بنشوف كتير من الفقهاء والقوانين الأنظمة تسعى لتحقيق التوازن العالمي وتوطيد العلاقات الدولية باتباعها هذا التخفيف من حدة Public Order Principle. This brings me to the end of my presentation. To summarize my main points, first, rules and values that form part of public order may vary from one state to the other and may evolve over time, and this including through court practice. Second, the concept of public order usually encompasses two dimensions: a substantial dimension, whereby public order refers to substantive law, values, and rules, and a procedural dimension, which means due process requirements. Third, public order exception is possibly the most effective and direct tool for protecting the defendant from the negative effect, as we explained earlier. And fourth and last, courts and tribunals generally refuse, on the basis of public order exception, to recognize or enforce foreign judgments that grant disproportionate damages awards or that were rendered in breach of due process of law or as the result of an abuse of rights. I hope this was useful. Thank you all for listening. These are the references you can read to add to your knowledge if you would like.